From item number 7 to 14, adjournment request.
With regard to item number 10, you must have been like to take up the matter.
Let this case, item number 10, let this case go out of our list and be placed before bench of which one of us, Justice Arup Chaudhary for a part. So, place this matter before the Chief Justice of the Industrial side for allocating an appropriate bench.
Deeply obliged. Your Lordship.
Yes,
From item number 15 to 28,
With your Lordship, I beg to mention item number 27. I have taken 27, Lordship. Phrase admission. So, meter may kindly be adjourned for today, Lordship.
what is it? Jorat Institute of
Lordship, this is,
Physical Education and all that. What is the matter? Why are you keeping it pending?
Lordship,
You are appearing for the appellant,
Yeah,
the
petition. Lordship.
Yes, have you informed the other side?
Yes, Lordship.
As prayed for on behalf of the petitioner after obtaining consent for the counsel for the other side. Let the matter be listed in on so date July.
Lordship. Problems.
15 July.
Lordship. Please, Your Lordship. Lordship, may I please beg to mention item 28 on the daily list?
28.
Yes, Your Lordship.
क्या करना है इसमें?
Lordship, while shifting chambers, we have misplaced the file.
You have misplaced the file. And this is a case where you have lesser merits to argue. And nonetheless, again, as prayed for on behalf of the petitioner, Mr. What is your name?
KG Chaudhary, Your Lordship.
Your?
I am on behalf of JMA Chaudhary.
What is your name?
KG Chaudhary.
Mr. Chaudhary, Mr. So-and-so, learned advocate on instructions from Mr. J.M.A. Chaudhary, the advocate in record, submits that the file of the case has been misplaced, and it will take some time to restore it, and it will take some time to retrieve it. For the aforesaid purpose, he seeks an adjournment. July.
17 July.
Deeply obliged.
From item number 29 to 38,
Mr. Lordship. Lordship, I beg to mention item number 30.
30?
30, Lordship.
30.
Yes, Lordship. Lordship, you filed the wakalatnama on behalf of respondent.
Manipur matter.
Yes, sir.
Lordship.
That Manipur matter.
Yes, sir.
Lordship, we filed the wakalatnama on behalf of respondent number 5.
But why can't you wait for the counsel for the appellant? I don't think you would press it any further.
Well, it's time.
Please for the appellant.
Well, it's time for the appellant.
You don't press it, no?
Well, I am pressing because
Okay.
this.
You've been promoted from an earlier date,
Well,
haven't you?
Well, it's the seniority is in question because the
What
private.
seniority? You have been promoted with a date by which those private respondents
Yes.
were promoted.
I'm-
Where is the seniority issue
Well,
then?
I'm disputing the promotion of the private respondents.
We have followed that.
Yes.
So you can't question it because the same DPC you were put on,
Right.
you were put there.
Well,
Anyway, the other side wants time and you're not very clear on the issue.
no,
I don't think you are losing out on any score.
well, it's my.
We'll say that this is academic now.
Well, it's my humble submission. Is that
Yeah, we'll see. As prayed for on behalf of one of the respondents. On whose behalf,
589, Lordship.
some of the respondents on whose behalf wakalatnama has been filed only recently.
Lordship, we don't have the copy, so Lordship, copy may be filed.
Recently, the matter is adjourned to so and so day. Please give her a copy.
I'm praying for a short date, well, it's because he's on the verge of retirement, the appellant.
How does it make a difference?
Well, it's because if he retires, then it will become infructuous. Well, it's our only submission.
So hasn't it become
Well,
infructuous?
Your Lordship, I kindly hear me just for 1 minute. If I'm challenging the DPC and I'm praying for a conduction of a review DPC, if a review DPC is conducted,
Preclude it from doing it. Anyway, we have the law with the contention which we are proposing. It is backed by law.
right?
You can't.
May it please, Lordship. Lordship, I'm appearing on behalf of respondent number 4 in this writ appeal. So, Lordship, my name may kindly be recorded.
assisted by.
Your appearance shall be recorded. That note is. But
Lordship.
then, yes,
But it's-
if you want an early date, we'll give you an early date. Let it be in May 2nd week.
Let's a date in April, let's.
April is impossible.
April, if possible.
No. April, we have only, no, 5 and plus for 9 days. No. If it goes in May, you can have it in first week of May.
First week of May.
First week.
Date may be given. No?
And take her name also. Senior Mamata Devi.
Assisted by myself, Your Lordship. Your Lordship, in last order, Your Lordship, 21/1/2026.
Which matter is mentioning?
Same matter, Your Lordship. I have filed a short affidavit as Your Lordship has directed to follow up regarding the service
Correct.
is concerned. Only thing is that there is some typical error, Your Lordship. I may be
Doesn't
allowed to correct. Your Lordship.
Doesn't matter. We will have it corrected manually when the matter is heard.
Okay.
Don't worry. It should not convey a wrong meaning or wrong set of facts. That's all.
That's that.
Correct.
Obliged,
Just be careful. There should not be any typographical error. But for this matter, we would not put you to the trouble of correcting it and filing another. We'll do it. Unless you have made a wrong statement.
No. That can be correct.
Correct.
6th of May.
But you do it manually on the day when we hear the matter.
Yes, obliged.
Correct.
obliged, Lordship.
May please, Your Lordship.
Yes.
Your Lordship, with due consent, I beg to mention item number 36 of today's list.
Why don't we go back to our chambers now? It's better that we go back to the chambers. All cases of hearing, all cases, if you have it adjourned. Item number 36.
36. Your Lordship.
Please don't. Please don't. This is the matter where reservation, the working out of.
No. There's a matter where we have challenged the penalty of sanction.
No. That's not item number 36.
36. There's 36.
Yes. That we can. What do you want?
It can be fixed after vacation. I've taken the consent of.
After summer vacation.
No, after this BU vacations.
BU holiday.
Yes.
You know the difference between holidays and vacation.
Vacations are.
Check it up and tell us. Right? Anyway, as prayed for on behalf of the petitioner, this appeal, as prayed for on behalf of the appellant, let this matter come up for consideration sometimes in July.
Obliged. 20th July.
You should be happy with the censor. There was a wrong statement given by you.
May I please, Your Lordship? I beg to mention item number 31, 32, and 33 of the daily list. Lordship, the petitioner would like to withdraw these matters, Your Lordship, as they have become infructuous.
What is your name?
N.N. Datta.
Mr. N.N. Datta, learned advocate who appears in all the matters.
Yes, Your Lordship. Your Lordship, however, in item number 34, we are awaiting instruction. That may be adjourned, Your Lordship.
No. Forget it. The liberty to approach whenever it is necessary. Mr. N.N. Datta, learned advocate who appears in all the forward petitions, namely so and so, submits that the issues have become infructuous and hence prays for withdrawing the same. Dismissed as withdrawn with the liberty to the petitioner to approach the appropriate forum in case need so arises in future.
Obliged, Your Lordship.
With please, Your Lordship, I beg to mention item numbers 38 and 39 of the.
38 and 39. Adjournment slip has been circulated.
Yes.
All right. Give a date.
14th July.
Obliged.
May I please, Your Lordship? Lordship, I want to list some urgent matters, my Lord.
You want to have some urgent matters listed.
Listed now. For today, my Lord. Lordship, we are really involved in the electoral rule, my Lord, but we are depriving to cast our vote, my Lord.
Abhi kya hoga? Nothing can be done.
Pulling
The elections are to be held on 9th. The state goes to polls.
we are including in the final.
अभी नहीं कुछ कर सकते.
In the final.
Use it as a ground for challenging the elections.
I am not.
What can we do now?
I am not challenging the election, my Lord. We are already included in the final list, my Lord. But we are depriving, my Lord, to cast.
Yeah, me?
Worship. In the final list, our name is included, my Lord.
कहीं नहीं. कैसे होता है? What can be done now? Before 2 days, what can be done? No, you are there in the voter list, no?
in the portal, my lord,
In the,
my lord, our name is not traceable, my lord, but in
it is
the,
not traceable.
yes, my lord, but in the,
From the authorities, they will
Honor-
put there. You have not been divested. You have not been held to be a non-voter.
no, my
Your name has not been deleted.
respondent stand is, my lord, our name is deleted, my lord, without any subsequent brutal.
Did you receive any communication from the authorities?
Lordship,
Have you received any communication from the authorities that your name stands deleted from the voter list?
before the single judge, my lord, respondent,
You're asking an appeal to be listed.
yes, my lord.
We will get it listed. Tomorrow, day after tomorrow.
Lordship, maybe possible tomorrow, my lord.
Tomorrow.
No problem.
Tomorrow. Say that single judge has rejected, you want it urgently before the elections. We'll do it.
Most problem.
Otherwise, I thought you're questioning some decision of the government straight away before the division. You're lucky.
Most problem.
We'll hear it tomorrow.
May please. My lord,
Inform the other side so that they are ready.
my lord, I have a similar prayer, different subject matter for listing of an appeal tomorrow.
What is it?
So in fact, after the, my lord, interim order, restraining the respondents to appoint in the post held by me is vacated, my lord. Now at any moment, my lord, the respondents, my lord, would appoint, my lord, a person. Third party right will be
It has to go after me.
my,
By specific order passed by a single judge, the interim stay order was vacated.
my lord, in fact, the writ of,
We are not going to
Writ
restore
petition
the
is-
order without issuing notice.
writ appeal is, writ petition is dismissed, my lord.
So otherwise we issue notice. What difference does it make? We are not going to do anything without hearing the other side. You know, Mr. Talib,
My lord, there is no private respondent, my lord.
even then, the state will have to be, the other side will have to be noticed, no? Will have to explain.
While your lordship takes up the matter, the state, my lord, will be represented by the government
No,
advocate.
what is that post that you are holding?
My lord, the finance officer, my lord, in the project under the state government.
And you are not retired, you have not been thrown out of the service.
I have been thrown out, my lord. I have been removed on a fact
From a post, not
Yes.
from the service.
of the service. I have been, my lord, removed from the, my lord, service.
Okay. And then removed from the service, so what difference would it make? If it is found to be bad,
My
you
lord,
shall be restored.
that I'll show your lordships, my lord.
So you shall be restored. Where is the urgency of today,
My lord,
tomorrow?
in fact, my lord, this is a post, my lord, on contractual basis. My lord, once it is filled up, my lord, I'm nowhere. I was selected pursuant to regular selection, my lord. And my lord, from the very beginning, my lord, to accommodate some third eye person, this is the third time, my lord. They have, my lord, issued impugn orders.
And
Earlier,
how do you say that they will fill it up with regular appointees?
they say, my lord, that the selection is complete. My lord, only it is awaited, my lord, for vacating
And you
the
had participated in the election.
selection.
the
No,
selection.
no, my lord, I was already there. My
You
lord,
may have been there,
yes.
but that does not preclude the state from initiating the recruitment process. No. You are a contractual employee.
Yes, my lord.
Whichever post you must be holding.
My lord.
You're a contractual employee.
I'm a contractual employee.
And they initiated steps for selecting people on a regular basis.
No, on contractual basis, which is
They
not
cannot.
permissible, which is not permissible also, my lord, in terms of,
Not permissible.
Piara Singh, my lord. Yes, Piara Singh, Uma Devi, my lord. I'm shocked to be thrown out by my lord, another contractual appointee.
What he gave Piara Singh, all of us remember.
Yes,
But
yes.
the difficulty here is that now all such posts are contractual. Now Piara Singh has lost its utility. These
My lord, this is one aspect of the matter. Your lordship will find that, my lord, I am shocked to be, my lord, removed.
We are not shutting you out. We are only on the question of giving you a hearing tomorrow or day after.
Correct, my lord, only that much. My lord, lordship,
Day after.
I'll take only hardly, my lord, 2 minutes. Deeply obliged, my lord.
Mentioning took you 5 minutes. How do you think that the matter would take more less than 10 minutes? Anyway, Friday, the last working day.
I'm deeply obliged, my lord.
Wait, please, Your Lordship. Lordship, I'd like to pay for listing of the writ appeal for tomorrow, Lordship.
How many cases will list for tomorrow? What is the urgency?
Lordship, this is a tender matter wherein the learned single judge has passed an order issuing notice. However, it has been decided finally, tendering the writ petition instructors. And in the meanwhile, they issue the tender notice, floated a notice. So, Lordship, may kindly take it up.
No, what is it? Just
Lordship,
come again. I didn't.
Lordship, the order was passed by the learned single judge wherein notice was issued. But it has been, the order that has been passed, it amounts to deciding it finally.
Amounts to deciding the whole
Yes,
issue.
Lordship.
How do you jump to that conclusion?
Lordship, in the meanwhile, they have floated another tender, which is
They can't, no, since the matter is sub judice, it can't be done unless the court has given the liberty.
No, it was not.
So therefore, there is no urgency.
No, liberty was not given.
Liberty was not given, so therefore you're safe. The
I'm
matter
not,
is still pending.
I'm not safe, Lordship. It is not subject to the outcome of the writ petition. Lordship, kindly consider, it will hardly take Lordship
And
10 minutes.
what is the reason why you have been ousted?
Lordship,
You have been technically disqualified.
in the price bid, I was disqualified citing a reason which was not even there.
You're disqualified for the reason?
I was issued the LOI, and after that, after issuing the LOI, they again asked for certain documents which we produced even before we produced, and later on when we produced, they decided that this is something we do not have. They are saying that we do not have. However, that is not the case. Lordship, that is why I'm just saying.
And what is the rationale of the single judge and not asking the other side or the tender issuing authority to examine that matter? They must have concluded it saying that these documents are not the documents which you demanded. Anyway, you may not be ready for so many questions that you're mentioning. Day after tomorrow.
Much obliged.
All right.
Lordship, I filed an IA, my lord, seeking withdrawal of the writ petition. Let it come up either tomorrow or day after. I was filing, my
For
lord,
what?
seeking withdrawal of the writ,
Tomorrow.
lordship, deeply applied.
Tomorrow.
May it please your lordship, I beg to mention a fresh motion for listing tomorrow, your lordship. It challenges the virus of the rule 16 and 22 of the chewing tobacco capacity determination rules.
Tobacco?
Chewing tobacco capacity determination rules, in short.
Chewing tobacco capacity determined.
Yes.
Capacity, whose capacity?
The lordship in that rule, cess has been divided on the basis of the production capacity of the machine.
Production capacity of the machine. It goes sometimes in May. Not tomorrow, day after tomorrow, not even in April, it goes in May. They challenge the rules.
Lordship, there is a statutory compliance timeline, your lordship. And if it is not,
Ask for some time. Statutory compliance is all right. There is always a leeway to the parties on it. Sometimes in May.
lordship, there will be prejudice caused to the petitioner. Lordship.
Sorry, May. Yes.
I do oblige.
Daily list for orders item 2.
The service on respond number 2 is not complete.
Awaiting the report regarding service of notice on respond number 2, the matter is there.
15 June. Item 3.
Yes.
In this case, service may not be complete, lordship. That as per the office note.
What is this about? Mr. Eki?
This is a review application we have sought regarding the challenge to the Assam Provincial Legislation Act of 2007.
Service is not complete.
Service is not complete.
Awaiting the service of notice on all the respondents. The matter is joint responsibility.
After summer vacation.
Small prayer losses last order to 19/6/25. I did wait for supply copy to ask lordship. We have not received a review petition lordships.
Ask Prof. Junior, Mr. Khatniar,
Yes, ma'am.
please tell him.
Yes, ma'am.
And we are fixing it in July.
22nd July.
Deeply obliged.
Mr. AG, if you are not otherwise engaged in other court, please be here. We will be required to ask you for some assistance in a matter. I don't remember which, but there has to be a matter.
Yes,
There is a matter here.
No difficulty.
We will have you called. You can, yes.
Item 4.
The service is complete. I pay for the respondent, on the respondent.
The service is complete. So the respondents are being represented by a counsel. Let this matter come up for consideration under the appropriate heading of admission on your day. Sometimes in May, June, July, whichever the date is free. Like, you like that?
15 July. Item 5.
During this case, I'm seeking some time, my lord. My lord has put some query, my lord. Instruction not received.
As straightforward on behalf of the appellant applicant.
My lord, this instruction, they have been, my lord, asking for because your lordship wanted whether it will be placed before the, my lord, the cabinet or not. That instruction has not been.
We are just placing it after view. All right. So I think it would be better if we keep it after fourth. Before the new cabinet, fourth, so let it be in the third week of May.
My lord, the only thing is, my lord, let them have the, my lord, clear instruction by.
As break for on behalf of the appellant applicant, let this matter come up for consideration on 18th of May.
That instruction maybe, my lord, then let them bring it, my lord, positively.
Instructions. I mean, you don't expect any instructions today within 2-3 days, Mr.
No, on the next occasion also, my lord.
Let the government be formed, let the elections be held.
Item 6 to 8.
Lord, in this pending appeal, we have filed this IA for a very limited purpose, my lord. What has happened, we are presently working as deputy director.
Yes.
Now 6 vacancies are there in the cadre of joint director. Now authorities are wants to go ahead with the selection process for the post of joint director. But because of the pendency of this case, my lord, they are not proceeding. Therefore, my only prayer is, my lord, let this process be initiated subject to the order.
We conclude the hearing whenever you say. Whenever you say, we'll conclude the hearing. Yes, Mr. Chaudhary, ready?
Yes, my lord, immediately on reopening, my lord.
Immediately,
I don't mean that week, maybe next week, my lord.
put it in the first week of May.
Yes.
We'll conclude.
My lord, first week that constitution then matter will be there.
Okay, second week.
Yes, but 12th, after 12th, my lord. Otherwise, my lord, what had happened in this case,
This IA.
our promotions were interfered with without we being party, my lord.
All right, we'll conclude it. We'll
Yes.
not place any interim order. We'll decide the matter.
Our lordship can observe,
Yeah,
they
but
may
that-
proceed with the without.
No, that would be allowing you.
I know the appellant in item number.
Allowing you there. We'll see. We'll see, but we will give you a hearing and we will have the appeal listed and decided.
Yes, yes, yes.
For final hearing.
Again, what is the number of, let the aforementioned IA. Bracket my IA civil number 949 of 2025 will listed along with WA number 285 of 2019 on 14th of May. 41 matters. 15th of May for final publication. But in the, under the heading admission.
Yes. Deep down.
Item 9.
And there are different appeals.
Make me your lordship.
Just a minute, so it depends. All the appeals can be done. Just look at it. Okay, there. 14 days. Either 18 or answer notice in respect of respondents number 11. 11 is the private respondent.
14, for only.
Yeah, fine.
Two of the private respondent entered APR as losses. One, as per information, he is known but not responsive.
He is not responding. Anyway,
Responding.
we'll give one more opportunity and thereafter we decide 14 days they are inclined.
14 days.
Awaiting the service of notice and representation of and appearance of all the respondents to contest this application of for condemnation of delay of 14 days in continuing the appeal, the matter is adjourned. We'll put it in the first week of May. If they don't
Yes.
come, we'll continue.
Obligation. Obligation.
Six. No, that's the future.
Teaching.
Item 11.
My lord, in this review application, your lordship should please to, my lord, condone the delay. And now, my lord, this has to be taken up for final consideration.
That's right. So the 74 days delay.
No, my lord, delay has already been condoned.
Delay has been condoned. Delay- Then you can spread at the time of hearing of review petition. Let this. Now. Really point of view. Wrongly, there's some wrong. उसमें गलत फाइल है. He was file was correct. No, no, different. All right. So, what date?
In the review petition, we want to file an objection because review is not entire project
File an objection.
will file.
But we'll hear it before that. Let it not come for.
Lot.
Here, review always comes in orders.
Yes. True. It is a rehearing of the entire matter. Lot of documents they have
That
taken.
is a
We will file an
ground,
objection.
Mr. Nath, for not entertaining a review petition. Put it on
Not-
record,
not-
don't
not-
put it on record, argue it out.
Full file.
Let this matter come up, let the IA along with the review petition number 206 of 2025 come up for consideration. Come up for consideration for the first of May.
Not. I'm like.
You want an early date? You want an early date?
Yes, madam. No, madam, let it be there, madam, because I have to in the meantime file the
All right,
objection.
let it remain on 21st.
Lot. 21st of May.
Item 12 and 13.
What is the review?
Just one small point. Item number 13, my lord, which is listed with item number 12, is actually supposed to be listed on the 4th of May, which the order has already been passed. We do not know how has this been tagged with item number 13, my lord. That's my difficulty. Item number 12, which is a review. We are not even made a party anywhere.
So 13 appears to have been 13.
I believe so. Yes, my lord, because the
Yes,
date
sir.
is 4th of May.
13, as in WPC number 4994 of 2025 appears to have been listed wrongly, as the matter has already been decided.
It's fixed on 4th of May. It's fixed on 4th of May.
Then we'll see on that day.
Yes, ma'am.
12th and 13th, let both the matters come up for consideration on 4th of May.
Item 14.
Wait, is it, sir? Also, here this review is filing, seeking review of the order, which is in past, which is at page 88.
Page,
88, your lordship.
page 88.
Yes, your lordship. Okay, what has happened on that particular year, which is 23/9/2020, the period of COVID has started. And for that reason, for subsequent 2-3 occasions, we could not appear. The orders
No
will be-
review of this order. You can file a fresh petition, ask for condemnation of it. No, you want a review of the order dismissing your petition for non-prosecution. I have never heard of it.
Also, we
I
filed-
really don't know that this is the procedure that you need to adopt.
also, we approached the earlier division bench by filing an IA, the order which has been annexed at page 116.
That division bench order also we don't agree to. फिर review कैसे देखेंगे? We can't pass any order on this. I don't know, you are asking this court to reread the provisions and the statutory rulings or something. Dismiss from non-prosecution, you file another petition, a fresh petition, why review? Say that it was dismissed. Proper application, perhaps the order dated 2012-2023. इसको review कराओ, get it reviewed because the liberty to file appropriate petition not application. I think the judge division bench meant that. You want a dismissal, we will dismiss it. 2020 matter and you're keeping it pending. You're flagging a dead horse.
No, Your Lordship. What is-
Now only on this ground we will dismiss it. We don't even give you the liberty. What, who advises you to do all this?
No, Lordship, what has happened when we filed a review?
What? No.
No, Lordship, I
We have followed. Now, therefore, if there is an observation instead of petition, if the court says application, it has to be understood in the context, no? And if you're so sanguine about all that, you could have got this, order corrected, modified, no review. The second order permitting you to file an application. What is this process? I don't know. We will dismiss it. We'll say that no, we get 2020.
No, Lordship.
Seek withdrawal to file appropriate petition challenging the order. That also unnecessary. We are not giving you any liberty. We are only allowing your prayer to withdraw in order to enable you to file something else. We don't know. Take them after some arguments, Mr. क्या नाम है आपका?
A.M. Mahanta.
Huh?
A.M. Mahanta.
So and so learned advocate seeks permission to withdraw this review petition in order to file an appropriate file an appropriate petition in case so deemed necessary. Dismissed as withdrawn with the liberty. Dismissed as withdrawn, no liberty. Dismissed as withdrawn. You file it, we'll see.
Item 15.
Both this measure 15 and 16 are still heavily concerned. Madam. In the item number 16, initially notice of inform was issued on returnable that it was not reached. And in fact, the
service report is in transit. Wait for some time. Awaiting the report regarding service of notice on respond number 1. The question is that
my humble prayer for notice when they while issuing notice of on the intent order was returnable. Madam,
22nd May.
next.
in time, there may be considered next step. Madam.
Item 16.
Like in this item number 16, we put steps, but in the office note, it is indicated that the speed, steps has not been taken. Madam, I will be allowed to, Madam, take these steps on the.
We have fixed a date. On that day, we will hear. Item number 17.
16. Madam.
But there's 17, but there's 16, but can. But otherwise, the notice has been received by respond number 1.
Madam.
No, he's received the registered post notice. Here, it appears that the regular notice has been, notice by regular post has been received by respond number 1. However, it has not been received. How do we say that? Okay, it appears that no steps have been taken by the appellant, by the petitioner no steps have been taken for issuance of speed post notice on respond number 1. But in that view of the matter, this petition ought to have been dismissed in the first instance. However, looking at the order which has been obtained in the present petition, which stands stayed in the meanwhile by this court, we give time to the learned counsel for the petitioner to file requisites for issuance of speed post, for issues of registered notice on respond number 1. On respond number 1. It appears that perhaps notice for requisites for issuance of regular notice by usual post has already been filed by the
Hello.
12 June.
returnable on funds.
Item 17.
For modification of this. For modification of the order,
Yes, Your Lordship.
why?
Your Lordship, the respondent, the petitioner, the IA of the petitioner,
You're there?
page number 32, Lordship has granted them 1 year time to shift their school. Now they have filed this application seeking 2 years more time.
2 years more time.
No, yes, Your
Sorry,
Lordship. Due to some financial constraint. Your
no,
Lordship.
no. Recalibrate your prayer. You want some 2, 3 months, 4 months, we allow that.
Your Lordship, we are facing financial constraint.
Whatever.
And
Take instructions.
the member of the.
Seek
Your
for
Lordship,
6 months more time, we can modify that order.
Your Lordship, the member of the committee themselves, we
I
have.
have told you, we cannot do it for 2 years. Better we set aside the order, or say that it is non-executable. But we can't give you such a long time. Take instructions from your client. If the prayer could be reduced for, extension for another 6 months, we are agreed.
Sure.
Take instructions tomorrow, day after tomorrow. Let this modification application be listed along with the content,
Contact petition number.
One of the 151/2012.
along with the content petition number so and so on.
Malab, it is the date is not fixed, Malab. After vacation, it's said, Malab. Or
Any time after
Malab,
July.
let me fix. Malab.
After July. What's that clutch? Orders दिखा लेना सभी में.
Okay.
22nd July.
Yes.
Item 18.
Well, this is why I for seeking condonation of delay of 26.
Notice private respondents.
Private respondents. The necessary party is respondent number 2. There are 3 private respondents for respond.
Notice will go to whom? What line? Hold on.
All the respondents, my lord.
Notice to all the respondents. Go to internal.
6. Item 19.
Be clear.
Your Lordship.
Let this IA be listed before DB3 for necessary consideration. Preferably on. Fourth of May.
Item 20.
First one. Private respondent. Notice both votes returnable. You're appearing.
My lord.
46 delay, my lord.
We are paying for all. My lord,
You're appearing for all.
the private.
Done within 46 days, we allow.
My lord, definitely, I don't have.
There's another. You're gonna put up. And Mr. So registered. Mr. Pathak appears for the respondent. So, good term. Delay condoned, appeal to the person. Like.
What can I pray for early then? These are matters of regulation, my lord. Some of them are retiring back. We are fighting this litigation from 97.
June.
My lord, definitely.
15 June.
Apply.
Item 21.
IA is for consideration of delay of 3
Respondents are
days.
government office.
Lordship,
Private.
private respondent.
Issue notice once, 3 days, yeah. Notice to so and so both votes returnable. June.
22nd.
Notice also.
22nd June. Item 22.
There's a delay in filing these.
Notice both modes returnable, August. I don't know that.
The respondent is
3rd August.
You're appearing.
objection, Lordship.
Not.
No objection.
No. Okay, was the I have written order 770.
Yes, sir.
Huh?
Yeah.
Day before, last Friday, I think.
I will give the IA number.
Huh?
I will give the IA number.
Good.
Give the idea.
Similar.
Appeal process, oh. They are not objecting. Don't be happy. They're not objecting because there's nothing in the appeal
So this is a covered judgment. No.
covered against you.
No, that's.
All right.
For admission, item 23.
May I please, your lordship? My lord, have limited my lord submission before your lordship. To the effect, a petitioner has, my lord, supposed to file my lord representation. He has not filed it, my lord, before the authority, indicating his problems, my lord. He's suffering from cancer.
We understand that.
Yes.
But then it cannot be questioned on the ground that it is because of
Yes,
standing
yes,
instructions
ma'am.
during elections. Now you do one thing. After the elections are over, you can ask for a transfer back. That's all. So that, you withdraw this, don't question this.
No, my lord, I am on, my lord. After passing of the order, page 62, my lord, petitioner is not in a position to file a representation because court has, my lord, opined something else, my lord. So, my lord, here is a case, my lord, where now his problem is that he is suffering from brain cancer and
Chairman, come on.
for that, my lord, clause 5 of the Election Commission guidelines, my lord.
Perfect. Now, let us see the order first. Let's see first the judgment, which according to you prevents you from filing a representation.
Lordship, page 63, my lord. Page 63, my lord. The petitioner is agreed by imping order dated 15/3/2026, where the petitioner should transfer from Morigao to Nagaon. The petitioner is working as senior inspector in the office of the DRCS Morigao, and by the imping order, he has transferred to DRCS Nagaon. The grievance of the petitioner is that he suffers.
Read paragraph 7.
Lordship.
How does
Under-
it preclude you from filing a representation now?
Yes.
You can always file a representation that now the elections are over. I have some difficulty. I'm suffering from cancer, or somebody in family is suffering from cancer. Let me post it to Nagaon, where I was earlier.
My lord, only the observation that court do not find any infirmity in the order. Accordingly, no interference is called for, my lord. He was transferred only 1 month, my lord. He was transferred from Nagaon to Morigao, considering his, my lord, ill health.
If you press that, we will.
No, my lord.
We will further reinforce it that it could not have been interfered. See, so we understand that, but the government your employer was not against you. It was only on the asking of the Election Commission, and it is the mandate on the state government to transfer such officials who are in the home district.
Yes, ma'am.
Nagaon is your home district. You have been transferred to Morigao.
Yes.
Now, after this, so this transfer order was not interfered with by the learned single judge. If you want us to reinforce that order of the learned single judge, we can do that in 2 lines. Now it is for you to file a representation. Now, clear the order which you are giving. This will help. Take it. By order dated 15/3/2000, we have heard Mr. So-and-so, learned advocate for the appellate. By order dated 15/3/2026, the appellant stood transferred from Morigao to Nagaon. Apparently, on the asking of the Election Commission of India, for the reason of Nagaon being the home district of the appellant. In view of the standing orders of the Election Commission, the appellant stood transferred, notwithstanding the fact that he has some medical difficulties. A learned single judge of this court chose not to interfere with the aforementioned order. And in our estimation, rightly so. After some arguments, Mr. Chaudhary seeks permission to withdraw this appeal in order to enable the appellant to file a requisite representation before the concerned authority for taking a sympathetic view of the matter after the elections, for posting him back to Nagaon on medical grounds. Dismissed as withdrawn with the liberty of force. Maximum.
Obligation.
Item 24.
My lord, matter pertains to my lord misappropriation of government fund.
Respond, Mr. Chandran.
Lordship. Under the DIDA.
Respond.
Lordship.
Taken. This public interest litigation seeks to address corruption and misappropriation of government funds allocated under the Mahatma Gandhi National Rural Employment Guarantee Act 2005, bracket Manrega. The focus of this petition is on the funds sanctioned for work in Lalung Gram Panchayat, including construction of inter-village gravel roads and areca nut plantations, totaling approximately to rupees 83.80, totaling approximately 83.5 lakhs. The contention of the petitioner is that the allegation of misappropriation is based on specific instances given in this petition, obtained through credible evidence like RTI responses and documents, which renders judicial intervention in the matter necessary. Mr. Chandran, learned advocate for the state of Arunachal Pradesh, seeks some time to respond to this much. Let the response affidavit be filed by the next date, notified July 8th.
27 Zulu. Item 25.
25 is my lord the identical.
Huh?
Identical matter, my lord. Only department is.
You are the advocate.
Yes, petitioner is interested.
Against Mr. Public advocate for the state of Arunachal Pradesh, seek some time to respond to this petition. Let him do so. Establish this matter same day.
27-7.
Obliged.
Item 26.
Net in lordship. My lord, this is petition for public interest, my lord, there. Under my lord, the provisions of MG and the Act, my lord, certain my lord, the schemes are approved, my lord, that, but department is not executing the works, my lord. In this regard, my lord, there is a provision for submission of, my lord, the representation, complaint, my lord.
Anyway, who appears for the state of Assam?
I'm for the PNRD department.
Mr. S. Datta, learned advocate, appearing for the state of Assam to respond to this petition by the next July.
Diploma.
29 July. Item 29.
Yes, sir.
Lordship, the petitioner is left in another court.
Who?
DK Soma is left in another court. Please get the matter for timely.
You are not entitled for any increments to leave without pay. These are the overall circular.
3 years gap period, my lord.
Anyway, on account of personal difficulty of Mr. DK Sharma, who is to address this court, the matter is adjourned to your date in May.
Kick me.
We have heard it a number of times. Tell Mr. Sharma to be present on the next day to take a dismissal order, unless he has something very, very interesting point to offer.
Item 35.
I could.
I score. Mr. Mahanta, where is the?
I want to file affidavit, my lord.
No, your affidavit will not do. Your affidavit here will not do. Look at this. Now, when we passed an order, this Mitra Chakravarti was not a party. This is which item?
Rubinath was not party.
Mitra Chakravarti was not a party. When was this? When did we pass an order? Division bench order? We passed an order on just a minute, 19 to 2026.
Yes, 19.
The same judgment which was impugned there is now being impugned here.
Here, my lord.
So this is, when was the appeal filed? P12. So 12. Now it was filed before this. The registry should have picked it up. And now with this judgment in Sajiv Roy, and the necessary, clarification in the Assam rules,
My lord.
I think they would be required to file a review petition. Review of this judgment of ours.
Division bench. My lord.
But this can't be ignored, no? Sajiv Roy.
Yes.
Have you read that?
Yes, my lord.
Yes, sir.
Sanjeev Roy, my lord, Sanjeev, your lordship kindly see the impugned judgment was passed on the basis of this Sadhna Singh Dangi.
No, we have followed that.
That Sadhna Singh Dangi case is, my lord, already, my lord, considering all.
Please, I'll read out what paragraph. Because this is fresh in my mind, because we were inclined to dismiss this. Okay.
My lord.
In the first instance, because we had already decided it on 19-2. Correct.
My lord.
Now, this judgment was not cited before us. And this judgment says, on an analysis of the aforementioned cases, we summarize, and one paragraph will tell you all.
My lord.
Whether a reserved candidate who has availed relaxation in fees, upper age limit, particularly in competition with general candidates, may be recruited against unreserved seats, would depend on the facts of each case. So far, so good. The others who have migrated, they have not paid any lesser fee or special privileges. That is to say, in the event there is no embargo in the recruitment rules or employment notification, such reserved candidates who have scored higher than the last selected unreserved candidate shall be entitled to migrate and be recruited against unreserved seats. However, if an embargo is imposed under relevant recruitment, such reserved candidates shall not be permitted to migrate to general category seats. Here what has happened is that the Assam rule says, this was what was argued by last occasion. Assam, you were the person who was.
Yes, sir.
Initially, we did not catch on to that point, but he did make out a point. In fact, this should have been heard on along with that appeal. Why don't you do one thing? What's your name?
Darakullalo.
So, Mr. Counsel, you do one thing. You file a review of this judgment. We will have it listed along with this. Nothing can be done.
Look, if I was not a party to that.
Doesn't matter, no?
Yes, Lordship.
You are directly affected
Yes,
by this.
directly affected by it.
Okay.
And this is during pendency, Lordship, because
You should have taken care. Your client should have told you that this matter is being decided. The same judgment was impugned in another appeal. You could have said, of course, whatever has happened, but we can't ignore this judgment of 2025.
That judgment, my lord, your lordship kindly see that your lordship kindly the judgment which was shown by my lord and my lord. That judgment is a two judges bench, my lord. And Sadhna Singh Dangi is three judges bench, considering the same, my lord. Same position is there, my lord. Madhya Pradesh also.
Mr. Mahanta, I would ask you to read this judgment again. This is an interpretation, a gloss put over the other things, giving primacy to the statutory embargo.
yes,
Statutory embargo by Bhavshovya one.
Let us do one thing. Now, we can't give deaf ears to this.
My lord.
Now, let a review petition be filed.
yes,
My lord.
Lordship.
Let a review petition be filed. We might go against him, saying that this has to be read in the context, in the bigger context of reservation policy. We might say so, but then you need a hearing. You're entitled to a hearing.
Yes, Lordship. Lot of other cases are also there, Lordship. I am doing research. Lordship.
My lord, if your lordship, my lord,
आप बहुत research मत करिए ना तो you will make the job of this court very difficult.
No, Lord.
because
We
my
are,
lord,
we are ready.
On the pertinent point, Lord.
But it should have been brought to our notice that you have also challenged the judgment. And Mr. Nitin, they should have made you a party because everything started with you.
They have not made party.
But you should have been careful, no? We passed an order, we upheld the judgment, we upheld the later part. Mr. Mahanta, you would have received a copy of the brief because you are appearing for the for the.
correct, man. Absolutely correct, man. But it was not my knowledge because they have taken time, probably. It was not in the first day they have done it.
No, Mr. Darakullah
Yes,
cannot be ignored now in this case. Let him file a review petition.
yes, Lord.
Review of which order will you file? Our judgment.
No, Lordship.
What no?
Lordship
File a
does.
review of.
Yes, Lordship.
Judgment
Little
number 27.
case. Vegetable, Lord.
We are suggesting you.
Yes,
Otherwise,
No.
otherwise we'll say that now that we have passed this judgment, nothing can be done.
No. Certainly, Lord.
But we are amenable to change because this was not brought to our notice.
Yes.
And I think it makes a change. Unless we distinguish it.
Lordship, we will file.
My lord, actually, my lord, that Sarna Singh Dangi case, my lord, there is a specific rule. But here, my lord, the case which is cited by my learned fan, there is only basis of the office memorandum.
Simple. Look at
The
this.
principle.
Now read your Assam civil.
Yes, only.
Where is that? Things have, whoever succeeds, we can't pass a wrong order, no.
My lord.
Mr. Mahanta, you are right, saying that this is based on a 3 judges judgment
My lord.
and this is a 2 judges. It doesn't matter, no, this was explained after analysis. This is the latest one. Now, this rule says, come to the relevant rule, Mr.
Yes.
Ullah.
Yes, Lordship. Rule 4, Lordship. Last part provided. Second proviso.
Read the entire of it.
Yes, Lordship. At the commencement of this act, 30% of the vacancies in respect of all appointment to the services and posts in the establishment which are to be filled up by direct recruitment shall be reserved for the women candidate. Provided that the aforesaid reservation shall be inclusive of the reservation provided statutorily or otherwise to the scheduled class, scheduled tribes, hills, other backward classes, more other backward classes, and persons with disabilities with their respective reserved category. Provided further that 30% reservation of the vacancies in respect of the women for the remaining unreserved category of candidates shall be available to the women of unreserved category only.
What could be more clear embargo against migration? What could be a more clear embargo?
That is, my lord, what is the embargo, my lord? Your lordship kindly seen the Madhya Pradesh also, my lord, is clear, rules was said this, my lord. But it was in Sarna Singh Dangi, my lord, the rule taken by the Madhya Pradesh High Court is found down by one of the appeals court, my lord. That is in Sarna Singh Dangi, my lord.
They follow that.
This is Madhya Pradesh rule, my lord. Your lordship.
Now this judgment takes care of Sadhna Singh Dangi and other cases sort of Trivedi or whichever.
Sort of that.
Jitendra Kumar.
In Madhya Pradesh, my lord, there are 3, rule 3, my lord, specifically, my lord, it was only for the general.
Sadhna Singh Dangi has been quoted. And it says that these observations, the division bench says clarifies, the strength of this bench was lesser, but it has been clarified. Therefore, this is binding on us. The observations in Sadhna Singh Dangi must be read in the factual matrix of the case which permitted migration of candidates in vertical reservation, unlike the present case. Here what had happened was that no migration was possible for the reason that the person who got migrated to the unreserved category, they had lesser experience, they had paid lesser fees, everything. So this migration was not possible. Otherwise, Sadhna Singh Dangi talks about the general scheme, under which how it has to be done. The top person, the unreserved category has to be defined. Any person who is in the top 4 gets the reservation. The last one in the four, if he's a male, he goes out. And the top scorer now gets there. If the top scorer,
If they are not availing
if the top scorer, that is not out of choice. If top scorer comes to, is from reserved category, then also she gets migrated. Correct. If there is no embargo like this. This is the general rule. Now, the explanation which has been given is that in Bharat Sanchar Nigam Unlimited Sandeep Chaudhary, the cutoff marks is also. On an analysis of the cases, we summarize, and then the paragraph which we read to you. So here, the Assam reservation rules specifically say that unreserved category for women candidates shall remain only exclusively for women of unreserved category. क्या करेंगे इसका? We did not take notice of it. We were not shown, I did not know. Let us frankly confess it was not brought to our notice and we were not aware. And ever since, I mean, my experience in division bench dealing with service matters, I have always dealt with Sadhana Singh Dangi and what is that case? Dadia and Dangi and Saurabh. This was the scheme in which I have decided cases in other jurisdiction also. This was not brought to my notice. To review the karna hoga na. Whether he agrees or not, like, take it.
I think we'll try to.
Hold on for a minute.
Yes,
no?
sir.
Begin. An advertisement was issued by the establishment of District and Sessions Judge Kachar, Silchar, for filling up of 11 posts of grade 4. In August 2022. The select list was prepared wherein one Litton Day bracket UR category was placed at number 4 in the merit list and was appointed to one of the posts. He had joined his duty in the year 2024. After 2 years of the appointment of Litton Day, the appellant in the present case filed a writ application, filed a writ petition before the High Court, alleging that 30% horizontal reservation for PWD and women candidates had not been computed properly in preparation of the select list. Her claim before the writ court was that she had scored 74 marks and was ranked 19th in the merit, and therefore she should have been appointed against one amongst the 4 posts meant for unreserved category. The writ petition preferred by the appellant. The prayer made by the appellant in the writ petition was not acceded to for two reasons, namely, that the appellant had claimed herself to belong to OBC category, but had applied as a general category candidate, and that even without considering her, the application of the horizontal reservation was found by the learned single judge to be not in accordance with law. The learned single judge had found, the learned single judge, referring to judgments of the Supreme Court, the learned single judge found out that the highest marks scored by a lady candidate, namely Sumana Paul, who had been selected in her category, in the category of OBC, in the reserved category, was required to be permitted to migrate to the unreserved category by removing Little Day from the select list, wherein he was placed in the last of the four candidates in the unreserved category. It was also found out that if Sumona Paul would have migrated to the unreserved category by way of horizontal reservation, one place would lie vacant in the OBC category, which was required to be filled up by the second highest scorer in the category of OBC woman candidate, which in that instance was one Ruby Nath, who originally was placed in serial number 21 in the merit list, placed at serial number 21 in the merit list. So this command the learned single judge had held was the only way to give effect to the reservation policy. The aforementioned observations were made by the learned single judge on the basis of the judgments of the Supreme Court in Rajesh Kumar Daria versus Rajasthan Public Service Commission and others, 2007, 8 SCC 785. Semicolon, Saurav Yadav and others versus State of Uttar Pradesh and others, 2021, 4 SCC. And Sadhna Singh Dangi and others versus Pinky Asati and others, 2022, 12 SCC 401. The directions of the learned single judge was implemented and the seats were worked out in accordance with what had been stated in the judgment. This had led to the ouster of Little Dev, who had to make way for Sumona Hall in the unreserved category. Aforementioned Little Dev had filed an appeal against the aforementioned judgment by W number 27 of 2000, which was dismissed by us upholding the judgment by judgment dated 19/2006. Mr. Darak Ullah, learned advocate for the appellant slash Kanu Mitra. Mitra Chakravarti, alias Kanu, submits that the appeal against the same judgment, this appeal against the same judgment had been filed on 3/12/2025 and was pending consideration of this court when the aforementioned appeal bracket WA number 27 of 2026 was decided, in which the appellant bracket Mitra Mitra Chakravarti alias Kanu was not impleaded as a party, notwithstanding the fact that the original writ petition was filed by him. Writ petition was filed by him. But Mr. Darakula, learned advocate, submitted that since the appellant was the highest candidate, was the candidate having scored the highest marks in the unreserved category, notwithstanding the judgments of the Supreme Court referred to in the impugned judgment, she had to be placed within first 4 unreserved category posts. The basis for submitting, the basis for this submission work is the provision contained in Section 4 of the Assam Women bracket Reservation of Vacancies in Services and Posts bracket Close Act 2005. Section 4 of the Act of 2005 reads as hereunder. Extract. Mr. Ullah submits that there is a positive embargo against migration in the proviso to Section 4, which makes it mandatory for accommodating the highest scorer in the unreserved category to a woman of the unreserved category. The scheme of working out the reservation, the horizontal reservation, has been explained in the judgments which have been quoted in the impugned single judge judgment, especially the judgment of the Supreme Court in Sadhana Singh Dangi and others. However, it was pointed out to us that the Supreme Court in Union of India and others versus Sajib Roy, not Sanjeev, Sajib Roy, 2025, 0 Supreme 2025 0 Supreme bracket SC 1652 has clarified that the observations of the Supreme Court in Sadhana Singh Dangi Supra, which looked into migration of women candidates availing horizontal reservation from reserved, that is OBC category, to unreserved category, wherein the recruitment process permitted migration in vertical reservation, but clarified that the horizontal reservation for women availing horizontal reservation from reserved, that is OBC category, to unreserved category, full stop. In Sajiv Ray, referred to above, the Supreme Court clearly stated that the observations in Sadhana Singh Gandhi has to be read in the factual matrix of that case, which permitted migration of candidates in vertical reservation and not otherwise. After analyzing all the cases on the subject, the proposition was summarized as follows. This is paragraph 32 legal of Sajiv Ray. Yeah, should I dictate? No. Take paragraph 32. We therefore are of the view that in view of this clarification by the Supreme Court in Sajiv Ray Supra and the specific provision in Assam, which was the act provision in the specific provision in the Assam Women Reservation of Vacancies and Services and Posts bracket close Act 2025, the judgment delivered by us on 19/2/2026 in WA number 27 of 2026 has to be given a relook. Mr. Ullal, an advocate, submits that he shall be filing a review petition. He shall be filing a review of the aforementioned judgment dated 19/2/2026, passed in WA number so and so, impleading all the relevant persons, including Lincoln Dale, Sumana Paul, and Ruby. As and when the review petition is filed, it be listed along with the present appeal, bracket W number 5 of 2026, and the records of W number 27 of 2026, bracket Little Day versus State of Assam.
Okay.
Preferably on जब भी file करिएगा तब तक. When you have made us think that day we were about to dismiss him. Otherwise, it'll be in complete disregard of Supreme. Unless Mr. Mantha has something.
No, my lord, I'll argue, my lord. I have some one point to argue. And Litton that median otherwise he'll go, my lord.
But in any case, we have to clarify that we have not gone, we have not arrived at a conclusion ignoring this judgment. Clarification, we'll see, we'll find out what is to be done. The entire scheme then gets frustrated. If this migration is not permitted, the entire stuff gets frustrated. That way, you're right.
No, otherwise, but open means open is open to all, my lord. That is the Ganges case is, my lord, basic, my lord, basic motto of the, my lord, Ganges case is there.
The primacy has been given to a statutory formulation.
The statutory, my lord,
there is an embargo. It says only a
when in Ganges case, it is cleared, my lord. Anyway, because there was a view taken by the Madhya Pradesh High Court, it was turned down by the
so the state of Assam, the High Court will go for a review of that judgment in Sajiv Ray. At least these contentions have to be taken note of. And this can be done only in review. Let's see. Preferably on give a date in July. First week of June. First week of June, Mr. Tarakullai is left. File it and we are fixing a date also. No, no, we can't fix a date. You file and mention, we'll fix a date.
No,
As and soon it is filed. File it, make a mention, we will put it. Otherwise, this order requires a rehearing.
Supplementary list, item 40.
No, no. These are a matter. Give us 2 minutes.
Yes,
Again, there is another administrative decision of the High Court which should require some modification. Let's see, we'll come back in 5 minutes, Mr.
Yeah.
Chairman.
If your lordship would kindly come to page 142 of the affidavit that answers the query, my lord. The present vacancy position has been reflected.
No, just a minute, Mr. Chaudhary.
Yes.
Let me to see the affidavit position.
Yes, yes.
Yes, Mr. Chairman.
Yes. My lord, if your lordship should kindly come to page 142, I think lordship has by now read the thing. Now, this is the own position of the High Court that vacancy position in grade 1 of Mizoram Judicial Service as on date is given below. So sanction strength on the direct recruitment is 5, regular promotion 9.
Okay, total 80.
80. Yes.
They say 594.
Yes, yes. Now, my lord, that serial number 3, Valnal Maya, he has also retired, my lord, on 31-3. Therefore, the vacancy position of direct recruit would be, I think, 2. Because including Abigail,
No. Including Abigail and
the gentleman will retire, my lord,
At
at
number-
serial number 3.
at number 3. So
Yes.
This two was originally notified.
Yes.
This two was originally
No,
notified.
in 24, only one post was advertised, my lord. Against that, initially Abigail was appointed, MS Abigail.
No, 2 was notified.
21-5-2, yes.
Against, then what? Abigail was appointed.
One and other was anticipated vacancy of this.
Now this vacancy, anticipated or not, the notification was issued. But by later notification of November, 1 out of the 2 posts newly created was clubbed. That's truly. ऐसा भी कोई बहुत गलती नहीं किया है स्टेट
नहीं गलती हुआ है.
ऐसी भी कोई बहुत गलती नहीं किया है.
No, I'll state where relearn Prem Singh, my lord. Supreme Court is very specific. I do give now. 1996 4 SCC 319.
No, we have in our introductory order
Yes.
on the first day, we have made note of it. But see, approval is not all that bad. See, only one, the present position now with the increased
Gather strength.
cadre strength, it has to be 4 only.
4. Look, we are not going to that dispute. Even direct recruit is also 4.5. We are also 4.5.
But we have decided.
5.
the High Court has
We have no
decided
problem.
Somebody, some grade.
Somebody has to lose out, yes. So we have no quarrel on that, my lord. So we'll accept as 5 for direct recruit, 4 for us. Now, my lord, the 2 should come to us, but both these posts should be for us. That's the point. Otherwise, my lord, say para 90 of Supreme Court judgment.
Decision had to be taken whether 4 would go to you or others. But,
Yes.
but then it could not have been clubbed.
Ha.
Unilateral.
Yes. That clubbing is the most difficult part.
That is.
Please have that, my lord. And there is no dispute that this vacancy which arose on August, that is a future vacancy. That is never in contemplation. Please have para 25, my lord. After discussing all the case laws on the point, this 3 sentence is very important.
Para
At
25.
para 25 at page 331. From the above discussion of the case law, it becomes clear that selection process by requisition and advertisement can be started for clear vacancies and also for anticipated vacancies, but not for future vacancies. So this is a very clear exposition of the law on the point. So the vacancies which arose on my lord 28-25 would not have been in contemplation of the appointing authority while issuing.
Solution, Mr. Mahanta,
Yes.
was interview, 21 persons have appeared.
Why we have, in para 6, I have explained, my lord, you have not to probably, my lord, for para 6, my lord, because in the para 6, my lord. My page 143, now.
Roman 6.
No, para 6.
Yes. Page 142. Yes.
The difference that again, the different basis state that the decision of fill up the newly created post through the ongoing recruitment process was taken consequent to the amendment of the vacancy position after the judgment of the honorable court that is so
But as per the terms of the advertisement dated 21/5/2025, more particularly the clause 5(2)66, whereby it is stated that the numbers of vacancies indicative only and may vary at the time of final selection. That was in the advertisement itself, it was stated. And that apart, issuance of fresh advertisement for filling up the newly created post would cause unnecessarily burden to the administration. And that is why, my lord, one process taken to this matter. That is the, my lord, only reasoning, my lord.
That is quite good. That's a good defense that you.
My lord.
That's the difficulty. This actually way in the administrative side of the, my lord, High Court.
And then, if your lordship, my lord, then it can,
Tested judicially, we are not.
my lord, then, my lord, we can, my lord, confine to only one, my lord, one post. Because an advertisement post two, one is already
Now you
illegal.
have to take a conscious decision whether you will give entire two it's by limited competition.
That
Because
would be a
that's
different
not-
decision, my lord.
Huh?
That would be on the administrative side, Honorable High Court will decide.
But
But for the
taking a
purpose of
decision,
the.
this is- So what is this solution now, Mr. Manta, tell us?
My lord.
We
Regarding,
will not undo the examination.
my lord,
We'll only reduce the post to one.
yes, my lord. So that is the only solution, my
What
lord.
do you say, Mr. Chaudhary?
No, my lord, ideally it should go to, my lord, my humble submission would be, my lord. What decision your eventual lordships on the administrative side take is a different question, my lord, we will not question that.
We reduce, we remove the clubbing.
Huh.
We leave that advertisement only for one post, which now has become vacant, which at the time of issuance was anticipated.
But newly created will remain same. Newly created, my lord,
We will take another decision in the administrative.
my lord, even, my lord, that is not permissible if you go by para 90 of the judgment, my lord. Kindly permit me to.
No, it will be permissible or not, we have not taken, I mean, the High Court, sorry, not we. The High Court has not taken a decision, no.
My lord, my humble submission is, even though selection has taken place. In
Selection
other
is
words,
not-
my lord, no, my lord, the written test is over.
No.
Oh, sorry, notified. So, my lord, I think this advertisement should be interfered with and High Court should take a fresh call, my lord, because there is.
That would, we will record your submissions, but yes, we will only reduce it from one. We'll reduce it for one. That will be in keeping with the advertisement policy, which says it may vary at the time of final.
That also has to be understood in the context of existing and anticipated.
Entire expenses, unless you say that with this vacancy, I could not have applied. Did you apply or not?
Now we have.
Therefore, we are entertaining this. You have
And
not- Were you eligible that time?
Yes, we are eligible. But
Number
my
of
lord,
years?
since the post was for direct recruitment, we cannot. We can apply only under LDC quota, my lord. Now, LDC quota is not there. That is our grievance.
No, so Mr. Chaudhary, we are agreeable to reducing the number of vacancy in this examination for which preliminary examination has been taken to one. That's all. We will not undo the whole thing. Nay, and then later you challenge whether all two newly created posts should go to you or because there, the direct recruit also will say that why we are being left out.
They are already having 4 million. We are having only 2.
No, but your 25% is.
No, we are 12 and a half.
ये तो अभी बाद में आएगा.
No, my lord, no, my lord, my only humble submission is as per para 90 of the Supreme Court judgment in All India Judges case. From 20th of May 2025 onwards, all recruitment has to take place in accordance with the new rules. And new rule has been framed. So therefore, all, including this, post should be
It
advertised.
saves the earlier thing. It says that there is
So it doesn't save me.
No, there is a paragraph which says that if any process initiated shall continue.
I'm coming to that. Please come to that para, my lord. 64, my lord. Para 90, my lord. Page 64, my lord. At page 64. Needless to state that all such recruitment process which have been kept in abeyance in view of pendency of the present proceeding shall proceed in accordance with the rules which were applicable on the date of advertisement notification. Nothing was pending. Advertisement is of 21/5. The judgment is of 25.
Because within 3 months, the rules had not been made, no?
No, my lord.
The rules had not been made.
The rules have not been made.
The rules have been made only in
But
2026.
to give a meaning to para 9, but this process was not pending,
We-
or it was not kept pending.
We have taken note of your argument, but we are not agreeable because we'll not allow the money to be wasted like this. A lot of expenses go in holding the examination. And then it will create then we have to call all 21 persons for cancelling it.
My only,
Then, Mr. Chaudhary, if you want.
in that case, my lord, now the two
Then
vacancies,
increase all those persons.
my lord, two vacancies, we can do, my lord, we can do that. Only thing is it will prolong. We can issue, we can make them parties in the proceeding. Because by participating in a selection process, no right as such has crystallized in their favor, my lord. Kindly see, my lord.
We are not getting persuaded. for this. Be satisfied with two. We will take a decision with respect to two of the newly created posts, whether it should all go to NC.
In that case, if the two newly created posts are advertised for LDC, then, my lord, we can take an instruction, my lord. Let the matter be called at 2 o'clock, my lord.
That the High Court will decide. Not now, the High Court will decide. ये अभी इतना कर सकते हैं उस क्लबिंग को हटा दो. And then the High Court will take a.
And we expect, my lord, High Court will while taking a call, take our grievance, my lord. That submission I am making, that submission can be recorded.
Submission will be recorded, definitely. While we take a decision, we'll do that.
Regarding filling up two newly created vacancies.
Correct. Your submissions can be recorded.
Yes, my lord. And in fact, my lord, this judgment not deal with the direct recruitment. This judgment only deal with the my lord LDC. Put the percentage has been increased, my lord.
How do we work it out?
Now that's why, my lord, this is my
That's good.
good suggestion is
We
there.
are happy with your affidavit, Mr.
My lord, sir.
We are absolutely happy with your affidavit, no difficulty.
Sorry.
The decision is, we don't say that the administrative decision to club it was so bad that it requires immediate intervention, but it is not in consonance with law within the four parameters, within the four corners of law. But this, that. Nothing, no great.
Already,
Which
my
has
lord,
been done up till
my
now.
lord, already, page 142, all of you kindly see, already, my lord, in promotion quota, already they are availing more, my lord.
But they are a separate category now. With the judgment, they are a separate category.
No,
They say that no.
regular promotion and LDC, my lord, percentage overall 75.
Maybe. But look at the language used by the judgment, by the courts.
So already, my lord, one exceeding that, man. That's why
That argument is not. That argument will not take it.
My lord.
We will.
Sorry.
Going by the history of this LDC quota, in 2006 it was 25, then it was reduced to 10, then now it has been brought back. I can appreciate, my lord, the stand which the High Court has taken. If similar positions have existed in 2006, then things would have been different, my lord. Now we are in 2026 when new rules are there.
These rules were not made, they advertised, and the intention was to avoid any delay in the matter in a point. And so they took care, they did not club all two. They took only one out of the two. But that decision does not make sense to us. I'm not confident. All right, this is what we are going to do. The application stands allowed to that extent, and we are at lunch.
And my lord, our
We have to be
submission.
we have to be careful in couching the order.
And my lord, our submission that
will
against
record
the
that.
two newly created posts, it should be earmarked for my lord, LDCE.
Both of it should be. All right, we are allowing your petition.
And basically our argument was based on para 90 of the All India Judges.
We'll deal with all this.
Milord,
We will, they will also find no great fault in the High Court and, but overall, we'll say that. That's a venial mistake.
My lord, one thing I have to be pointed out, my lord. If your lordship reduced to 21 posts, my lord, then my lord, we have already called 21 candidates. So that percentage of ratio, will
Doesn't
be-
matter.
that will be, yes, then
We will indicate that.
my lord, indicated.
Otherwise, it would have been lesser.
Please, I will be 10.
Doesn't matter. And fortunately for the High Court, the notification says that this vacancy position could be altered. But because of the judicial decision,
My lord.
this is not being done. So I think that will be covered. But of course, if anybody wants to contest that, that can also be contested. But we will see. But now, as of now, like in the earlier case of Little, they were working on reservation.
And then another point, my
my
lord,
lord, in Litan's case, there is a Supreme Court judgment Anil Kumar Gupta of 95 to SCC.
And they have incorporated
Yes.
that.
And there is a division bench judgment of our High Court also.
But now,
Rasul Mohammed.
but the Supreme Court is very clear about the scheme and how the working of the scheme, how it is to be done.
I was following the case. My only concern was, my lord, this migration is a concept which is associated with vertical reservation. That is why, my lord, in Anil Kumar Gupta,
But
Supreme Court has said, first you fill up all the posts according to the roster.
Dangi says that open means open to all.
that is the language used, madam.
But fortunately or unfortunately for either of the parties, either of the class, either of the grade, Assam Act of 2005 clearly says that only don't migrate. So this clarification came only later, no? It came in 2025 about which this bench did not know. We passed an order affirming the working out.
Without that order, later
that-
order,
No, without.
25 order.
Yeah, correct. So it has to be modified. But the only way out was the single judge applied Sadhana Singh Dangi. The government followed suit by working it out, removing one person.
And another aspect, my lord, our Assam Act uses the expression vacancies. My lord, it is directly in conflict with our case overall. My lord, whether it is vertical reservation, whether it is horizontal, it has to be post-based. How can the vacancy be relevant? I think that's a misnomer, my lord. Otherwise, if vacancy is taken as the basis, then the number will go on and it will exceed 50%.
Vacancy and posts, they match.
Hmm.
So there is no mismatch here. Just the expression, but nonetheless,
Anyway, deeply obliged, my lord.
in fact, all these matters of migration, civil services and all, civil services, there is some justification because with your migration, you get a better service.
Right.
But otherwise, Rajesh Daddy has civil services, no?
Yes.
I think
Rajesh Daddy has civil services. But otherwise, this nation is, of course, Dangi is a 3 judges bench. Mahanta rightly pointed out. But Sajeev Ray says that Dangi should be understood in that context.
in the facts of that case.
How can we say once it has been brought to our notice, we can't say that.
Deeply
On that point, my lord, I have answered, my lord. That is regarding rounding
Let
up,
the review of our judgment with
my lord, regarding rounding up 4.5, it is 5 days as husband, my lord. This is not wrong, my lord.
that is, he's not
No,
questioning
that
it.
can be, that can be either way.
Either way,
But it is
there
High Court's call,
but
which High Court has taken, that we are
He's
not.
not questioning it now.
My
We will
lord,
not enter into
my
that.
lord,
We will only
And that
record
is not the subject matter
it.
here.
We will only record his submission that these 2 posts also, if they are advertised, they should go to limited. Which we will not accept that. We will only record his submission.
my lord.
And then full court, honorable court will decide on the administrative.
Deeply.
All right, application allowed to the extent indicated. Score. G. Discuss.
Item 37 for hearing.
Where is Mr. Chaudhary? Where is Mr. Chaudhary? Just call Mr. Chaudhary. Yes.
Please, your lordship.
Madam, this PIL is for issuance of ration card for the marginalized community in the 3 districts of Arunachal Pradesh. And also one of the prayer is for setting aside a notifications.
Of 2019-91.
Yes, Lordship. And that creates a barrier for issuance of ration card for 2 communities. So this there is. And
do
also
you say-
sanction.
Ms. Ghosh,
Yes, Lordship.
how do you say that between 1964 to 69,
Yes, Lordship.
because of the communal violence and that Kaptai Dam,
Yes, Lordship.
these migrants, Chakmas and all, they came to Arunachal, they were made to settle in parts of Arunachal Pradesh
Yes, Lordship.
by the government. How do you say that?
By the government of India,
But
Lordship.
how do you say that?
Because that is the background, Lordship. If we see the judgment, 1994
Is there a
judgment.
government decision to make?
Yes, Lordship.
Otherwise,
Yes,
91, first, this PIL, you have to question the 1991 circular if it is still in operation. Where is that circular?
circular I have annexed along with my page number 121, Lordship, of my PIL. (122), Lordship. 122.
What does it say, really?
May I read, Lordship?
Yes.
Circular, it says that with reference to the sign of DC Changlang wide message so and so of 25/10/91, it is to inform all concerned that issue of ration card to refugee like Chakma, Hajong and Tibetans has been banned by the government.
And where is that banning order?
We have only this copy and hence no ration card will be issued, renewed for Chakma.
Now, where is this?
Lordship,
You have to bring 2 things, Mr. Chandran. Number 1, where is the government decision of banning it for others? And number 2, where is that decision of the Union of India to be executed by a state of Arunachal Pradesh for allowing these refugees to settle in Arunachal Pradesh? Once you allow them, then it is under your orders. Then you can't divest them of their entitlements for food under the Food Security Act. Food Safety and Security Act. And these are the 2 arguments that Ms. Ghosh is making. Where is your affidavit?
Lordship, our last affidavit, it was filed on Lordship 24th of March, Lordship.
What have you said?
Lordship, in this affidavit, Lordship, page number, Lordship, so it starts from Lordship page number 453. And Lordship may come to page number 472, Lordship.
472.
472, Lordship. That is a communication sent to us by the government of India, Lordship. Therein, Lordship may come to Roman 4 and 5, Lordship. That Roman 4, it says that the coverage under NFSA can only be revised after the publication of next official census data as per section 9 of the Act. And Lordship, Roman 5 says that currently Arunachal Pradesh receives so and so metric ton of food grains monthly.
Yeah, that's all right. That's all right. Where is Mr. RKD Chaudhary? He will have to answer this. He will have to answer this. Have you understood what we want to know from him? Have you understood what we want to know from him? What?
And it is not that we are not giving them the ration, Lordship. As per the initial order of this Honorable Court, Lordship.
Ask Mr. Chaudhary to be here. Ask Mr. Chaudhary to be here at 3 o'clock. We will assemble again for delivering a judgment. तुमको खबर कराया था चौकी all right, we here let's see what Mr. Chaudhary is.
Yes, Lordship.
We are only concerned with the fact that this National Central Act has to be given effect. Now, can you deny that if you have made them, if you have granted What the status is that called? Refugee, refugee, no, there is something else. There is an expression which says that if they are refugees under one particular category. Yeah.
Lord, may I submit, Lordship? They are now not refugees. Hardly 10% who has migrated, they are alive. Rest all are by birth and Indian citizen. Lordship, even the
That
national,
you stated in your application. petition.
yes, the Lordship, even the National Human
Let us
Rights
see, Mr. Chaudhary,
Commission
what
also,
is his response, then we will see.
and the citizenship of the who are by birth, and even the Delhi High Court judgment, which is also not challenged by the government of Arunachal Pradesh before the Supreme Court. Then this is the reason their name are enrolled in the voters list. And yes, they are giving to the voters. If they are giving to the voters, Lordship, they are giving, father and mother is receiving the rice. But what about the children? They are the minors. So their name is not there in the voters list. So this is a discrimination on that aspect.
Correct, we are agreeing. Let Mr. Chaudhary respond.
Yes, Lordship. And even as per the PDS order 2015, Lordship, every year there has to be a revision of the
No, it
ration
says
card.
only after census.
No, Lordship, as per the PDS order, government PDS order 2015.
PDS, see, PDS is targeted beneficiaries.
Yes,
You don't fall in that target.
let me complete, Lordship. If I am able to satisfy Lordship. One thing is that now they have said that saturation point is over. So if today I'm marginalized, maybe next year I got a government job in the grade 4 employee. So my status changes. So as per the previous order, if a government servant, whoever is employed in government is not entitled for ration card. So my ration card for next year, if I get a job, government job, is a bogus ration card. That means I'm not entitled under the priority household. My status changes. So every year, in none of their affidavits, Lordship, that they are doing revision every year. And out of the court, one thing I'd like to submit, I had made a survey, even both the parents are working in government, ration, they have the ration card. They're availing the ration card. But this is, as per the PDS order, which is there in page number 440, Lordship, which I have annexed in one of my reply, which says that the state government shall regularly review the list of eligible household for the purpose of deletion of ineligible household or inclusion of eligible household. So not a single statement is there in the affidavit that every year they are making the revision. So there is a chance of inclusion, Lordship. And in another one affidavit, Lordship, as per the Government of India letter, Lordship, page number 175, wherein my learned friend had brought in that letter, 5th November 2021, Lordship, where is, may I read that, Lordship?
We have followed your argument. We have followed your argument. It's not under this embargo.
Yes.
The state will have to answer this.
Yes.
Because we must have a clear instruction of the Union of India
Yes.
that they are not refugees now.
Yes.
They have been made to settle that part of Arunachal Pradesh. Therefore, they are mandate refugees. That the word is mandate refugees. They were. Now with their children having
Yes,
taken birth in the country,
Yes.
I think they are naturalized. So therefore, they can't be excluded from the benefit of the National Act, Food and Safety Act number 1. And if that goes,
Yes,
this embargo goes,
Yes.
then under PDS, it has to be yearly revision.
Yes, Lordship. This is my only submission.
No, that's a very strong submission that you've made. It doesn't make much of a difference, no? These are limited numbers.
Yes, Lordship. And there are Adivasi communities also. We have prayed for marginal. We are not only targeting, we have prayed, in our prayer is for marginalized community.
Then you get everything what a citizen is entitled.
Yes, Lordship. Yes, Lordship.
Why do you have to segregate that?
I'm not segregating, but
you get everything. What
yes, Lordship. Yes, Lordship.
Lordship, in the survey which they have conducted, Lordship, there other than the Chakmas and Hajong, there is no other names, Lordship. The survey was conducted only for Chakmas and Hajong.
That was during lockdown period, Lordship.
Can you make that a ground?
No, but
made by Mr. That's not a ground. Question ye hai ki they are if they're citizens now, can they be kept out of the application of the National Food Safety Act? And perhaps PDS. That's the only question. That is the filter rate of our submissions. We keep it on some other date or we ask Mr. Chowdhury to be here. At 3 o'clock. Or
Yes.
we will submit at 3.